Did you know that the estate planning process can be a minefield for the uninformed? The process of estate planning involves the coordination of the various assets of an individual or a family into a cohesive, comprehensive plan for the purpose of reaching particular, well-defined goals. The real trick is to come up with an effective overall and integrated strategy to deal with and protect assets. Hello, my name is Attorney Ramsey Bahrawy, and welcome to Your Money, Your Life. In this segment, I will discuss the basic rules of asset protection. We've all heard the old adage, knowledge is power. It's a great saying because it really is quite true, so long as one knows how to use that knowledge. Quite frankly, that saying couldn't be more appropriate when it comes to protecting your assets. Did you know that most people who consider asset protection often have very specific goals in mind? However, they lack sufficient credible information to execute their ideas. Allow me to share with you what I often hear from a client. Somewhere during the course of an interview, a client will express his or her thoughts. That conversation usually sounds something like this. I want to be able to enjoy and benefit from my hard-earned assets. I also want my spouse and children to enjoy the full extent of these assets. In other words, I want to pay the least amount of taxes and preferably none if possible. Also, if my children marry, I want my assets to be protected from division in a future divorce. After I pass away, should my spouse remarry, I want to be sure that my spouse can't pass my assets to his or her new spouse who potentially diverts them away from my children. Also, if I need nursing home care, I want the government to pay for my care. Bottom line, I want to be sure that none of my creditors can reach any of my assets. And of course, I don't want to give up control while I'm alive, but remember, keep the plan simple. Whew. Now, doesn't that sound like someone who wants his cake and eat it too? On a more serious note, I'm glad when my clients give these matters substantial thought. However, what this hypothetical client doesn't realize is that this type of planning encompasses many different considerations and areas of law. Stated differently, this client requires an estate and financial planning team which is familiar with estate and gift taxation, trust law, property law, partnerships, limited liability companies, corporations, family law, conflicts of law, and ERISA. The team must also be familiar with debtor-creditor law, which includes bankruptcy. They also need to be familiar with the tax laws relating to offshore trusts and LLCs. And then in some cases, it is important to be familiar with the laws of foreign countries. In this discussion on the basic rules of creditors' and debtors' rights and asset protection, my focus will be on Massachusetts law. So let's get started. Court decisions reveal a never-ending battle between creditors and debtors. Debtors want to protect assets by using entities such as limited liability companies, corporations, family limited partnerships, and trusts in order to keep assets outside the reach of their creditors. Creditors, on the other hand, want to be able to reach all of the debtor's assets in the event of a default. As a result of this ongoing battle, certain fundamental principles have developed and emerged. These principles are codified by the Uniform Fraudulent Conveyance Act and, more recently, the Uniform Fraudulent Transfer Act. You will note that these 6 principles seek to be fair and balanced. They are: first, creditors can reach benefits that the debtor can reach. Second, creditors can receive what the debtor can receive. Third, creditors can reverse an unfair or fraudulent transfer of assets. Fourth, creditors can have a debtor's assets placed in the hands of a receiver. Fifth, creditors can attach, freeze, and/or force sale of a debtor's assets. And sixth, creditors can force a debtor into bankruptcy. Please take note that most fraudulent transfers may be attacked by both present and future creditors. So how does a creditor know when to bring an action for fraudulent conveyance? Simply put, the creditor brings an initial litigation to establish its debt or claim. It is during that litigation that the creditor learns that the debtor is without assets to satisfy the judgment. At this point, the creditor must then undertake a separate proceeding during which the court conducts a separate hearing to determine whether transfer was fraudulent. Such secondary proceedings can be drawn out and expensive. In other words, the creditor is looking at maintaining and paying for 2 separate actions in order to either rescind or reach transfers based on the fraudulent transfer rules. All legal actions are subject to something called a statute of limitations, or the time by which a lawsuit must be filed. The filing of the lawsuit tolls the statute of limitations. In other words, it stops the clock from running. In general, the statute of limitations on fraudulent transfers in several states vary. I will limit my discussion to the Massachusetts rules. In Massachusetts, there are 3 limitation periods. First, if the transfer was made with intent to hinder, defraud, and delay, the creditor has the later of 4 years from the date of the transfer or 1 year from the time the creditor should have reasonably discovered the transfer. Second, if the transfer was constructively fraudulent, 4 years from the date of the transfer. And third, if the transfer was a preferential transfer to an insider, 1 year from the date of transfer. When a creditor claims a fraudulent transfer, it has the burden of proving the fraudulent transfer by what is called the preponderance of the evidence. In other words, the evidence must show that the allegation of fraud is more likely true than not. Obviously, before a creditor goes to the trouble of bringing a separate action alleging a fraudulent conveyance, it should undertake an analysis of the debtor's financial condition and likelihood of success in pursuing the fraudulent conveyance action. However, protected assets are not considered in this calculus. An example of a protected asset is a qualified retirement plan account. However, IRA accounts are not exempt in all states. Please be aware that there is a distinction between a fraudulent transfer and a fraudulent conversion. Generally speaking, a fraudulent conversion occurs when an action is taken which transforms an asset that may be reachable by a creditor to one that is either not reachable by a creditor or becomes harder to reach. When a client first seeks to establish an estate plan, a team of advisors attempts to develop a plan which achieves a client's family, business, and philanthropic goals. In so doing, the team of advisors needs to be mindful of asset protection so that the family wealth is not dissipated through unforeseen events such as lawsuits, physical disability, or a sudden downturn in the economy. That can involve protecting income, protecting property with a limited liability company, or insulating financial assets within an income-only trust. Whatever technique is utilized, it is axiomatic that asset protection planning, when done correctly, needs to happen well before a potential creditor problem or issue arises. The key is early planning, as the future is unpredictable. When engaging in asset protection, there are 4 basic entities which are typically utilized to protect assets from creditors. They are first the trust, second the corporation, third the limited partnership, and fourth the limited liability company. When engaging in asset protection planning, a person's goal is to legally move, place, or arrange assets in a manner that is beyond the reach of creditors. Of course, this must be done without violating the fraudulent transfer rules. The legal advisor's goal is to assist the client in a legal and ethical manner. Accomplishing the goal of asset protection also may place the assets beyond the reach and enjoyment of the individual. Hence, while the assets may be protected, control of those assets is also lost. Moreover, in many cases, the assets are exposed to creditors of the transferee. Let us consider an example. A transfer made to an adult child will not only leave the transferred asset beyond the control and enjoyment of the transferor, but they will be reachable by the creditors of the child as well. One could consider a partnership. Partnerships protect the assets of the partnership itself from the debts of the individual partners. The partners, however, other than limited partners, are fully exposed to the debts of the partnership. For instance, say that 3 stooges open a candy company as partners. Mo and Larry are general partners, and Joe is a limited partner. In a separate business deal outside the partnership, Mo runs up a personal debt. Most creditors cannot reach the assets of the candy company. On the other hand, if a deal within the candy company goes sour, the company's creditors can reach not only its assets, but also the individual assets of Mo and Larry as general partners. Joe would have no personal liability for the partnership debts. Now let's consider corporations. The corporate structure may be the oldest and most familiar of asset protection structures. A shareholder's personal liability for corporate debt is limited to the shareholder's investment in the company. Now let's consider the limited liability company. The limited liability company, or LLC, represents a more recent entity created by statute. The LLC is a hybrid between partnership and a corporation. The members are analogous to partners of a partnership, but unlike partners, they are by law protected both from the liability of the LLC and the liability of the individual members. This protection, however, is not absolute. LLC assets in the U.S. are always under the jurisdiction of U.S. courts. Now let's consider trusts. Utilizing a trust may in some states offer the best domestic protection without giving up the benefits of the assets in question. Typical estate planning trusts for a married couple generally take the form of revocable reciprocal trusts funded during lifetime, designed to take advantage of the state and federal estate tax marital deduction through something called the Credit Shelter Bypass Trust. Single persons will also often have a trust funded during their lifetime. However, a single person utilizes a trust for asset management and privacy reasons. It is important to note that the rules in every state are different. Let's look at spendthrift trust rules. A spendthrift trust is one containing a provision stating that the assets of the trust shall not be reachable by the creditors of any beneficiary. As a general rule, in the great majority of jurisdictions, a spendthrift provision in a trust established and funded by a party other than the beneficiary will protect the trust's assets from the creditors of the beneficiary, with only certain exceptions. However, if the beneficiary is also the settlor of the trust, a self-settled trust in other words, the general rule is that the creditor of the settlor can reach whatever settlor beneficiary can reach, as well as whatever benefits the settlor beneficiary could enjoy. Assuming, of course, the trustee exercised its maximum discretion under the terms of the trust. I hope this presentation made you aware of the fact that preparing an asset protection plan, whether for a healthy or disabled or an aging person, without the appropriate tools and assistance can be a dangerous journey indeed. What I discussed today are only the highlights. Do not act on any of the information provided on this program until you've consulted with a lawyer competent in asset planning techniques. That's our program. My name is Attorney Ramsey Bahrawy, and as usual, thank you for watching Your Money, Your Life, Building Your Trust.